Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, today we are here to talk about the co-owners of a reasonably valuable shopping centre. What happens is that there are a number of agreements that governs the way the co-owners were to co-own this shopping centre, and those agreements have a number of terms, as agreements tend to do. And one of those terms related to the nature of certain transfers of shares in the shopping centre that would be prohibited by the agreement. And the nature of that prohibition was that if you and I were involved in the same sort of agreement, if you engaged in one of those transfers, then it would give an automatic right to me to buy your shares at a certain amount to be determined pursuant to a valuation, intended to be the market amount. So it's not a penalty price, but the penalty, as it were, would be the automatic operation of my right to purchase your shares from you. All right, I think you know where we are going. So in about 2012, we have a share transfer from the sort of 50-50 arrangement turning to like a 50-25-25 sort of arrangement. That transfer actually proceeds in accordance with the relevant agreements, and so it's pretty much fine. There's another transfer that we're going to turn our attention to, though, that happens a number of years later. Now, if I can just zoom out a little bit, the shopping centre we're talking about is of reasonably considerable value, and the co-owners in the shopping centre are sort of part of, broadly speaking, the same sort of group. And there's an interest in respect of each of them to say, hey, I only want to be in business with certain parties, and I want to have sort of prior approval before I have to go into business with other parties. Does that make sense? So if we go back to our example where you and I have signed up to the same sort of agreement, I don't want you to go off selling your shares to just anyone, because I might then find myself co-owning a shopping centre with some idiot who you've decided to sell your shares to. Similarly, I might go off to sell them to someone, and you might be a little bit disappointed to find yourself in business with someone you don't approve of. And so that's sort of the commercial background here to kind of say, hey, look, you've entered into an agreement that gives something that can loosely be analogized to a bit of a veto power for a potential purchaser of shares. So as I said, in the past we had these compliant transactions. Then we flash forward to 2022. One of the co-owners, the sort of relevant co-owner, engages a moderate complexity sort of restructure. And because I'm not a big transactions lawyer, it feels somewhat complex. I'm sure there are much smarter, better lawyers than me that understand it better. But in essence, we have this share of the property, the share that's going to become the defendant's share, being transferred out of the hands of the original co-owner and into the hands of a new co-owner as part of their sort of reasonably complex, reasonably valuable sort of restructure flavoured transaction. Now, importantly, the transferee, the person, the owner, the eventual owner at the end of that restructure, does not fit within the definition in the agreement between you and I, and the agreement between these co-owners of a relevant related party. So the argument arises. What the plaintiff says is, hey, you've transferred your shares into the hands of someone you shouldn't have, and so bing, that activates the automatic purchase provisions of this contract, where I can go send you an appropriately prepared valuation. I'll send you an appropriately prepared contract based on that appropriate valuation, and bada beam, bada boom, bada transaction, you have to sell your stuff to me. The plaintiff does that. Right? There are emails exchanged back and forth between the solicitors where the plaintiff solicitors say, hey, this is one of these default events. It means that my person can buy it from your person, and the sort of defendant solicitors say, that's not how we see the world. And in short, the plaintiff presses the point, the sale does not go ahead, and so the plaintiff considers they have to go ahead with court proceedings, and so they commence those proceedings, and that's what we'll be talking about today. So, that's cold. The plaintiff says, in essence, re-puts their argument, right? Says, hey, there's a contract entered into. One of the terms was that if the defendant was to transfer the shares into a party's hands falling outside of this definition of the relevant related party, then that'd give rise to this automatic right for us to get appropriate valuation, send out a nice proper contract, and we can have the sale take place pursuant to that contract. Now what the defendant says is no thanks, we don't agree with that. And the two sort of limbs of no thanks that the defendant sort of presses in relation to this no thanks, one of them is a reasonably technical argument that arises from the sort of pretty intimate detail of the relevant agreements, as well as the pretty intimate detail of the sort of moderate complexity restructure. And in part because it's boring, and in part because it's difficult for me to have complete command of each of the relevant terms of the contract when it's just you and I having a chat in a coffee shop, we're going to sort of gloss over that broadly to say that the court was not convinced by the defendant's arguments in relation to that, and found that the outcome of the restructure flavoured transaction was that it was shares being transferred out of the hands of an appropriate party and into the hands of what I'll loosely call an inappropriate party. And so, based on the characterisation of the restructure the defendants argued for, and the characterisation of the deed or the agreement that they contended for, the court did not agree with what the defendant said and agreed with what the plaintiff said. Now, the other element, or another element, raised by the defendants in their attempt to resist the plaintiff's argument, and what I might have said is that the valuation the plaintiffs came to and the final contract they sent through was for $830 million. So it's a transaction of some size, and both parties see it as a size worth arguing about. And so we have the second reason that the plaintiff resists, I withdraw that the defendant resists the plaintiff's view of the world in relation to, and that's in relation to notice. Right? You might have recalled earlier I said that it was the lawyers for both sides who were exchanging documents. Plaintiff's lawyers send an email, defendant's lawyers receive it, reply, and that we've got these things going forth by email. And so there's this question about notice that's raised by the defendants of like, all this stuff is emailed, and the deeds have a section, or the agreement I should say, if I'm speaking loosely, has a section that deals with how notice is to be how notices are to be given pursuant to the relevant arrangements, and there are addresses for service and people to serve things to and that sort of thing. Well, that might be right insofar as it goes, but there is an additional element that says there's no formal or ceremonial requirement for notices. Notice merely needs to be in writing. Crucially, all that the court found the plaintiff needed to prove in relation to notice was that the defendants actually got it. There was evidence before the court that the relevant proposed contract that sort of triggered off the transaction and all of the plaintiff's rights came into the hands of the defendant's lawyers, and the defendant's lawyers sent it on to the defendants themselves. And so, by the defendants receiving that email from their lawyers, by the defendants getting notice in writing that this is what the plaintiff was trying to do, that's all the plaintiffs had to do. It didn't have to be some formal or elaborate process, merely in writing and prove that it came to the defendant's hands. And that was able to be proved, so that notice argument fell down. In dealing with that point, the plaintiffs had raised an argument, something to the effect of an estoppel arose, right? Suggesting the defendants were estopped from departing from their representation, that if you send something to our lawyers, you're sending it to us, or estopped from departing from their representation, that notice to our lawyers is enough for us, that's notice pursuant to the arrangements. Now what the court said was there was some strength to that argument, and the court gets into sort of analysing it a little bit and picking it apart, but finds ultimately does not uphold the estoppel argument. Now, that's just a little bit of extra discussion for us today, because as we learned earlier, the notice point was made out because there's no formal or ceremonial requirement in relation to it. And so, what is the end result? The end result is that the plaintiff is found to be successful. The plaintiff's notice and the sending off of the $830 million purchase contract is found to be completely fine and appropriate, and the court finds it's appropriate that the parties proceed on the basis that that is well within the contractual rights and obligations of them both. I hope that decision assisted you, and I look forward to chatting again soon over another coffee and in respect of another case note. Cheers.